Welcome. My name is Kyle O'Dowd, and I'm the Associate Executive Director for Policy at NACDL. NACDL and its First Step Implementation Task Force are carefully monitoring DOJ's actions in response to the new law and providing NACDL members with resources needed to represent their clients effectively. To that end, we are pleased to bring you this second webinar on the First Step Act. Our first webinar, available to stream on NACDL's website, dealt with the Act's criminal law and front-end sentencing provisions. Today, we'll focus on changes to compassionate release and related back-end relief mechanisms. We are thrilled to have with us three preeminent experts in federal sentencing and prison issues, among many other topics. Speaking first will be Mary Price, General Counsel for FAMM. Mary is one of the nation's leading voices for sentencing reform, most recently heading up a compassionate release clearinghouse that she'll mention later. Peter Goldberger, speaking next, is a nationally renowned appellate lawyer from Ardmore, Pennsylvania, current president of the Pennsylvania ACLU, and a recipient of NACDL's prestigious Heaney Award. And Shon Hopwood, speaking last, is a professor at Georgetown University Law Center, an appellate specialist, a reform advocate, and a very busy national speaker. To provide a brief overview of our program, Mary will frame the issue and its historical context, explaining how we got here. Next, Peter will detail changes to compassionate release and related measures under the First Step Act. And finally, Shon will highlight theories for pushing the envelope and other considerations for advising incarcerated clients and dealing with the BOP. Our speakers will present until about 2:15 Eastern Time, after which you can sign off or stick around for a 10-minute Q&A. Please send your questions to kodowd@nacdl.org. If we don't get to your questions today, I promise we'll try to provide answers in the coming days. First, Mary's going to start us off with an 8-minute video.
Thank you.
I've never shared that story before. My dad was born in Iowa on a farm, 2 hours southeast of where we grew up. You have this person you identify as your dad, and then all of a sudden they become this convict. If you say outright wire fraud, well, then you must be really, really wealthy and have this, extravagant lifestyle growing up, which wasn't the case at all. He had no prior convictions, sentenced for 5 years when he was in prison. My father was diagnosed with bile duct cancer, October 5th, 2012. They thought it was stage 3 or stage 4. At 5 years, I didn't think my dad would make it out and that he would die in there. The very first time I saw him, I had a hard time stopping myself from crying because it was evident that he was very sick. And I finally got a hold of the doctor, said, okay, so he's sick, how does this work? And she said, they talk about having compassionate release, which is a program that allows prisoners to be released early if there are extenuating circumstances. And my father, from all we had been told, would be a really good candidate because he was given 3 months to live.
With compassionate release, the statute says that upon motion of the Bureau of Prisons, the sentencing judge can consider compassionate release for extraordinary and compelling reasons. So the process has to begin with a motion from the Bureau of Prisons. Those motions were few and far between, and they interpreted that essentially, not entirely, as we're only going to release people who are at death's door.
The BOP holds all the cards, and that you're bound by whatever the BOP says, and kind of has the power to do what it wants to do. First, you have to go through the warden twice, then paperwork has to be sent to the general counsel, and then if they approve it, it goes to the BOP here in DC, and then if they approve it, then it goes back to the judge, and the judge commutes a sentence. All these steps take just an incredible amount of time. He had 3 months to live. They knew that, and you would assume if someone's given 3 months to live that you need to review paperwork as quickly as possible. But that is not what happened at all.
You have to navigate your way through an administrative structure that is not easy to understand. And you have to do that when you are impaired in some way.
One of the things is when you submit these paperwork, you have to fill everything in. So my dad then would have to go in and take the form and handwrite and everything. He's handwriting all these things out, and you know how much effort it took for him to write at this point. My mom asked if she could submit the paper for my dad, and she was told that she could not do that. My dad had to be the one to fill it out. A large part of it's a mental game. And when you tell someone that they're not going to get out, it's difficult. And then when he got denied, he pretty much gave up. He had 2 weeks left to live.
Who can be served by his continued incarceration under these circumstances? Who is helped by that? The quality of society is measured by how we deal with the least fortunate. And the people in our prisons are the least fortunate. This makes an enormous difference to us as a society. It's the measure of our humanity. And when you go through the litany of purposes of punishment, there is really none that justifies the continued incarceration of someone who is so impaired that they cannot function in prison, so in pain that they cannot deal with the prison environment, as well as people who are about to die and should be with their family.
On the very last day that I saw my dad alive, I pretty much knew it was going to be the very last day I saw him. And I had 30 minutes with my dad alone. To say everything that you need to say. And you can never, you never, how do you say everything you need to say? 30 minutes. They call time, and everyone gets up. I realized, this is the last time I'm never going to be able to hug him. And I gave him a hug. And I told him that I loved him. And he told me he loved me. And he was crying too. And then I had to walk away from my dad. And I knew that would be the last time. On the day my father died, January 2nd, the doctor called my mom and said, Alan's not doing very well. You need to come now. From what my brother says, my father was in a lot of pain. And then after 2 hours, they kicked them out. And then my father died by himself.
There were horrible stories of people whom they had turned down for compassionate release and they died immediately after. There are even stories of people whom they agreed to give compassionate release to and died on the bus going home. The Bureau of Prisons is the gatekeeper here. Unless they interpret their regulations more broadly, nothing happens. The continued incarceration of someone who was so ill that they could no longer commit any crime doesn't make sense under any rationale of punishment. The crime rate is not going to skyrocket if any of the cases of compassionate release that I've seen led to the release of the person. What will happen, the person will be allowed to be at home, perhaps die with dignity. Public will be saved the money of their care, and the society benefits from being a more humane society.
I don't know why it's so difficult. I don't know why compassionate release can't be granted. And no one's given me a reason yet for that.
I think that the Bureau of Prisons should be given the responsibility to report to the sentencing judge about the prisoner, but the determining decision maker should be the judge, not the Bureau of Prisons.
No one sees the humanity of prisoners. I don't think anyone benefits from being denied compassionate release. You're denying individuals. None of us want anyone to have experienced what we went through. So I am in law school right now, and hopefully to become a lawyer who helps those who can't help themselves. I think you would be happy that I was doing this.
I arrived at FAMM just about 19 years ago, and from the very first days being there, I began to hear from prisoners and their loved ones who were seeking information about how to secure compassionate release from the Federal Bureau of Prisons. People like Allison's mother, Mr. Rice's wife. We listened to heart-wrenching stories from families trying to help sick and dying prisoners navigate what's an unusually complicated and opaque system. They didn't understand how to ask for compassionate release. They didn't understand what the criteria were, and they certainly didn't understand why they were being denied and turned down. They received little or no help from the Bureau of Prison staff. Instead, they were met with walls of silence, ignorance, misinformation, and sometimes hostility and unkindness. And as Judge Gertner pointed out, they endured lengthy delays. In a 4-year period, 81 people died in the Bureau of Prisons waiting for an answer from the warden or from the central office to their request for release. And also, as you know from the slide, most people were turned down. Even people who met the very narrow criteria that the Bureau of Prisons set out for compassionate release. Mr. Rice was turned down not because the Bureau of Prisons thought that he had not met the conditions for compassionate release. They knew he was dying. The warden turned him down because he decided that Mr. Rice had not spent enough of his 5 years in prison. So how do we get to this situation? In 1984, when Congress passed the Sentencing Reform Act, they strictly limited the ability to revisit a sentence once it had been finalized, but they carved a couple of narrow exceptions into that rule of finality. And one of them is when an individual develops what are called extraordinary and compelling reasons that would warrant a reduction in sentence. That's what we call a compassionate release colloquially. When Congress set up that program or that authority, they divided the job of defining and conducting compassionate release among 3 bodies. To the Sentencing Commission, they gave the job of defining what is an extraordinary and compelling reason, and the job of advising the courts, giving the courts guidance about how to evaluate a compassionate release motion. To the Federal Bureau of Prisons, they gave the job of identifying prisoners who met the criteria established by the Sentencing Commission, and then bringing those cases to the court's attention by way of a motion for a reduction in sentence. And finally, to the sentencing court, it gave the job of deciding whether or not the individual met the criteria and evaluating whether they ought to be released in light of the Sentencing Commission's guidance and in light of the sentencing statute, 18 U.S.C. Section 3553A. That was a nicely constructed system, but it was broken from the very beginning, and for 3 reasons. First of all, the Sentencing Commission didn't get around for over 2 decades in writing the criteria for compassionate release or providing any guidance to the courts. And so, of course, into this breach stepped the Bureau of Prisons, and they wrote their own criteria, and some of them were fine. They had to do with terminal illness and debilitating medical conditions and things like that. But they also took on the job of defining whether or not somebody ought to be released. Did release pose a threat to the community? Would release minimize the seriousness of the offense? These were all things that we and others believed had been committed by Congress to the courts. The second reason why the thing broke down was because the BOP had been given the exclusive right of bringing the motion. So if they felt that somebody didn't deserve to be released, they simply didn't bring the motion, and therefore there was no opportunity for a court to make a ruling. And finally, prisoners were given no right to appeal an adverse decision or the neglect of their request. And so no meant no. So there were lots and lots of efforts over the years, obviously, to fix this. There was efforts to get the Bureau of Prisons to change its practice and get back in its own lane. That didn't work. Many of us worked to pressure the U.S. Sentencing Commission to write the criteria for compassionate release, which it finally began to do in 2007, I believe. Lawyers, especially federal public defenders, went into court and challenged, argued that the Bureau of Prisons was acting outside the law by taking the law into its own hands. And then, of course, there were efforts to expose the problem by educating the public and members of Congress. So in 2012, my organization and Human Rights Watch wrote a report called The Answer is No, which sort of sums it up. In 2013, the Department of Justice watchdog, the Inspector General, wrote a scathing audit of the Bureau of Prisons Compassionate Release Program, and it generated some small reforms. And in 2016, the United States Sentencing Commission revisited its old guidelines on compassionate release, expanded some of the criteria, and took the opportunity to wag its finger at the Bureau of Prisons to say, look, if somebody meets the criteria that we've laid out here, bring the motion. The courts are in the best position to address them. But of course, none of that worked. The Bureau of Prisons continued to sort of thumb its nose at Congress and the Sentencing Commission. And we all at that point knew, if we hadn't known before, that only Congress could fix this problem. We knew that given the opportunity, that judges would evaluate and rule on motions, even motions that would not otherwise have been brought by the Bureau of Prisons. So compassionate release reform was enacted as part of the First Step Act and went into law at the end of December of last year. How compassionate release became a part of the First Step Act is probably a story for another day, but I will tell you the video that you just saw played a rather large role. I'm going to come back at the end to talk about how you can get involved, but Peter is now going to talk to you about the statutory and regulatory rules and how compassionate release works in the courts.
Thanks, Mary. So, as Mary mentioned, the First Step Act is a very large bill. It contains many different provisions, and when you hear your colleagues or maybe your clients say, oh, I may be eligible for First Step Act release, it's very likely they're not talking about reduction in sentence for extraordinary and compelling reasons, which is what we're going to be talking about for the next hour. They may very well be talking about modifications in drug sentencing and other provisions, which is probably the most common sense in which people say First Step Act relief. They may be talking about the increased rate of good conduct time. They may be talking about the extra good conduct time provision, which will go into effect, we hope, some months from now when the risk assessment provision is shakes out its wrinkles. So what we're going to talk about is one small part of it, half of Section 603 of the statute. And let's start by, and the title slide that you're looking at now on your screens, I imagine, mentions that there are two early release provisions in the First Step Act, both of which are in Section 603, one 603A and one 603B. 603A is about opportunities for early transfer, redesignation to home confinement, and we're not even going to be talking about that today. We're going to be focusing solely on the changes made by Section 603B of the statute, which is to say the reform of the reduction in sentence provision, that the background for which you heard from Marianne in the video. What was done to change the tragic circumstances that you saw illustrated in that video? Well, the substantive standard, interestingly, was not changed at all. All the changes that were made were on the procedural side, and yet the changes are profound. The most important of which is that the prisoner, the defendant, the inmate, now can file the motion in court. So the decision, the opportunity to consider whether the factors warrant release are now where they ought to be, in the hands of a federal judge. Which judge? The sentencing judge. So this is not always good in every case for every prisoner, for sure, but it's a heck of a lot better than being in the hands of the warden or the general counsel of the Bureau of Prisons, exercising authority for which they have had in the old system no competence and really no legal justification either. So what are these unchanged substantive criteria, which I'll be talking about for the next 25 minutes or so? The court may reduce the sentence if, after consideration, or let's say reconsideration, the statute says consideration, but really we mean reconsideration, of the 3553A factors, the same factors that a judge looks at the time of sentencing, to the extent applicable, says the statute, an interesting what does that mean thing that we may come back to. The court finds that reduction is warranted for extraordinary and compelling reasons, but only if that decision is consistent with applicable policy statements, in this case a policy statement of the U.S. Sentencing Commission. So you can tell from the language, warranted, consistent with, consideration of 3553A factors, multiple levels of discretion are built into this system. There is no such thing as being eligible and therefore you will be granted. This is being eligible and therefore you can be considered in the discretion of the judge. In some cases that's a good thing, other cases it will not be a good thing. That's the way it is. The applicable policy statement is section 1B 1.13. That's the one that the Sentencing Commission belatedly issued a first draft of in 2007 and the current version in 2016. Notice that in the statute, the words compassionate release are not used. The word terminal illness is not used in these criteria. This is not a provision, contrary to the way it was formerly enforced by the Bureau of Prisons, which is solely for those who are on death's door. This is for prisoners whose circumstances have changed in such a way that a fair-minded person could think that there were extraordinary and compelling reasons to change the sentence. So some key points that are already implicit in what I've said. Right? The amended statute allows the prisoner to file their own motion, or the prisoner by counsel to file their own motion. But there is a sort of an exhaustion of remedies requirement. That is, you can either exhaust the entire administrative remedy process in the Bureau of Prisons, or the lapse of 30 days after the request for relief is received by the warden. That is, in every case, going to be a shorter period of time. And we were chatting before we started the video about whether we could even imagine a case in which it would be to the prisoner's benefit to wait for full exhaustion of remedies. And I suppose if you have, the only case I can think of, and I'm not sure there really is one, is a bad judge, an unsympathetic judge, in a case in which the Bureau of Prisons is very likely to say yes, so that the judge is much more likely to grant the motion filed by the U.S. Attorney's Office at the behest of the Bureau of Prisons than by the defendant, even under the same circumstances. That's a rare case, and I'm not sure even then it justifies waiting the 30 days, because you file in court. Sometime after you file, they will complete the process and maybe they'll endorse your position if it's a case of the kind that I posited. So we'll see. It applies, an important answer to a question frequently asked. This provision, unlike some of the provisions of the First Step Act, this provision applies to all federal sentences without exclusion. Life sentences, mandatory minimums, sex crimes, violent crimes, all can be eligible for this relief. Doesn't mean the judge is always going to grant it, but nobody is per se ineligible. The statute requires the judge to consider and be consistent with Sentencing Commission policy. Sentencing Commission policy says the judge should always consider danger to the community. Maybe in that respect, some of those cases that are per se ineligible for other forms of relief won't get granted, but they're not per se ineligible. And I think Shon will be mentioning later that there are even arguments why the danger to the community requirement is unlawful and not enforceable. We'll come back to that later. And the other common situation that the proffered extraordinary circumstance that you're putting forward as your basis for your motion was readily foreseeable, anticipated at the time of sentencing. Sure, the person's been in prison a long time. I gave him a long sentence. Of course he's going to be in prison a long time. Sure, he's old. He was middle-aged when I sentenced him, and now a lot of time has gone by. He was young when I sentenced him, and a lot of time has gone by, and now he's old. That's not extraordinary. That's normal for a long sentence. That's not disqualifying logic under the statute.
The BOP hasn't figured that out yet, by the way.
Well, so they're right, and so I'm getting there.
Oh, I'm sorry.
That's the last key point, what Mary said, but it's a very important one, and I can jump there right now, which is the fact that the BOP says no to the request, the fact that you have to make a request to the warden first. What's the warden going to look at when you make the request to the warden? Whether you meet the standards under the statute in relation to the Sentencing Commission criteria, which is what the judge is supposed to decide? No. What the Bureau of Prisons is going to look at is whether you meet their criteria under that old program statement of the Bureau of Prisons that Mary alluded to earlier that was non-compliant. They're still following. Yeah, they amended it after the First Step Act. It's better than it was, but it's not fully compliant with this new statute or with the Sentencing Commission criteria, and yet that is what the Bureau of Prisons is going to follow. So the important thing to understand is when the Bureau of Prisons turns your guy down, that does not impair his or her chances of being granted in court, because what's happening under the statute is not administrative review of a Bureau of Prisons decision. It's a de novo decision by the judge applying a statutory standard. And if you go back to that statutory standard, 3553A factors, extraordinary and compelling under Sentencing Commission criteria, there is nothing in the statute that says consistent with or upon consideration of criteria of the Bureau of Prisons or after considering the decision by the Bureau of Prisons. In fact, the reference in the statute to the Sentencing Commission without a reference to the Bureau of Prisons by normal statutory construction would say that any deference to the Bureau of Prisons is prohibited by the statute by comparison to the way it talks about the Sentencing Commission. And the Sentencing Commission, by the way, when it says consistent, when the statute says consistent with the policy statement of the Sentencing Commission, that's not the only provision of the federal sentencing law that comes into play here. Because in the part of the Sentencing Reform Act of 1984 that set up the Sentencing Commission, there are two provisions in which Congress expressly delegated to the Sentencing Commission the authority to say what shall be considered in extraordinary and compelling circumstances. So it is arguable by reference to those provisions, that is 19 in the top point here, section 994A1C and 994T of the statute in Title 28, that these provisions are arguably binding and determinative, that the decision of what shall be considered sentencing compelling and extraordinary is not one of those discretionary decisions. That's a legal decision, and the decision to define those terms was delegated to an agency, an expert agency, that is the Sentencing Commission. The commission, the statute, by contrast, only gives two examples of things that are per se criteria. One is a no and one's a yes, right? In 994T, it says that rehabilitation alone shall not be considered extraordinary and compelling. Well, okay, but the key word there from the defense lawyer's point of view is the word alone. Rehabilitation is a relevant factor by implication under this statute in cases to which it applies. And I would say the other implication of the statute, and this is a provision added by First Step Act, there's a long section in of the amendment under the First Step Act that talks about special rules in terminal illness cases. So I think by implication it follows that a terminal illness case, as we saw in the video, is necessarily a kind of extraordinary and compelling circumstance. So the Sentencing Commission criteria, there we go, sorry, are articulated in the policy statement 1B1.13, as I said, and its application notes, which are equally important. In fact, for you sentencing guidelines nerds, there's no difference between a policy statement and an application note to a policy statement. They have the same weight of authority under the guidelines. You will you'll find, reading those, that the criteria that the Sentencing Commission has articulated fall largely into three baskets: age, time served, health-related criteria, family circumstances criteria, and, importantly, an open-ended provision called other circumstances, which Shon is going to mostly be talking about today. And arguably, it says, that provision says other circumstances as defined by the BOP. Question is whether as defined by the BOP is no longer a valid limitation after the statute's enactment, and that there is now a fully open-ended opportunity for other circumstances. So let's talk first about the biggest basket, which is not one that was frequently used under pre-reform experience, but now is clearly the biggest basket: age, time served, and health related. I would say probably the majority of applications that prisoners are filing now that you will hear about from your clients or get questions about from your clients, or which you may be wanting to follow up on by filing in court after your client has applied to the warden, will be one of these. Within this general category, there are four things to look at: how much time has been served, how old is the inmate, what's the inmate's health status, and what is the impact of age and health status on the ability to get along in prison. There are a number of criteria under the Sentencing Commission policy statement that function as different combinations of these four criteria. The first ground articulated by the Sentencing Commission, and therefore the first kind of release a judge could give that would be consistent with policies of the Sentencing Commission, would be terminal illness, the one we've already been thinking about and talking about. The statute added the First Step Act added a whole new subsection to 3582, so that is D, that talks about special rules for terminal illness cases. The most important, one of the important parts of which is that it defines what shall be considered terminal illness in this universe. And what's important about that is it's an illness with an end-of-life trajectory, not necessarily an illness with a certain life expectancy. So when the warden says, but you have more than 18 months to live, so we're not going to consider you for terminal illness relief, the warden is not complying with the statute, and the judge should give that no weight after 30 days and just go ahead and say, what, from a medical point of view, is the trajectory of this diagnosis? I have one pending right now where the U.S. attorney says, but the doctor at the prison said that, under public health statistics, your client has a 50-50 chance of living 3 years with the cancer that he has. That's a terminal illness. It's, that's not disqualifying. And if the inmate has a terminal illness, then no other factors are relevant. Not age, not time served, not impact on ability to get along. Terminal illness is a standard by itself. Now what about, and I'm going to skip over, except calling your attention to take a look at the statute when you get a chance, to 3582D. Not 83D as it says on the slide, but 82D, my typo. And that is the new statutory rules for terminal illness cases, each of which is responsive to one of the things that was wrong with the old process that you saw described in the video. That is, family members may submit the request, the lawyer may submit the request, you can't force the sick inmate to fill out the stupid form, it has to be processed promptly, there has to be a special relaxation of the visiting rules and so forth.
Not quite being enforced yet, but
and I have not seen any evidence that any warden is aware of this statutory provision or thinks that it applies to them, because it's not contained in a Bureau of Prisons program statement, and therefore, from the warden's point of view, is not a law. The second ground, now we're talking about criteria that involves some combination of time served, health, impact on ability to get along, right? The second ground, which I call reduced ability to provide self-care. The inmate has a serious medical or physical condition, not necessarily age-related, not necessarily after serving a long time, but a serious medical condition or a serious functional or cognitive impairment, so it can be mental or physical, from which the inmate is not expected to recover. So it's not short term, it's chronic, and which substantially diminishes the inmate's ability to provide self-care in a correctional environment. If you have that combination of circumstances, and I would give as probably the most common example of that would be advancing diabetes. There are a lot of inmates with diabetes who are cared for very poorly in prison. Diabetes is affecting their ability in various ways to provide nutrition, being ambulatory, things like that. That's probably the largest, in my view, the largest category that fits there.
You could also imagine that there might be cases where someone's significantly diminished and can't protect themselves in prison.
Right, and the question is how narrowly or broadly would you define self-care?
Yes.
If self-care includes in the prison environment, as
Yes.
Shon is pointing out, and I hadn't thought of this, but that's a great point, is the ability to defend yourself against harm from others. You don't think of it necessarily that way in the community outside.
Yes, but given how violent many of the BOP institutions are, and someone's been put in a wheelchair and cannot protect themselves.
Very good point. And I've used just ability to walk quickly enough to get to pill line, ability to walk quickly enough to get to commissary or to chow hall at the time you're required to be there for the short period of time you're allowed to be there. That's a kind of self-care that maybe wouldn't be what a physical therapist would call self-care in the outside world.
Another one on the cognitive side is whether or not somebody understands, can comprehend, and follow an order.
Good point, yes.
So we see that also.
Very good, very good. So now the third, we seem to be getting ahead of ourselves somehow.
Third ground, here you go.
This is sort of jumping, sorry. On the third ground covered by Sentencing Commission criteria is the impact of aging. The way this one reads is because of the aging process, the inmate is experiencing deteriorating physical or mental health that substantially diminishes the ability to provide self-care. The difference here, add aging, subtract serious. The condition need not be serious, as under the criteria that we were just looking at, but it has to be caused by aging. Otherwise, it's quite similar to what I called the second ground. The fourth ground is an age and time served combo. This is your combo platter for age and time served. The lesser of 10 years or 75% of the full term. So 75% of the full term, I did the math for you, will be less than 10 years if the sentence is under 12 and a half years, which is to say 150 months. Then that's still going to be less. Otherwise 10 years is the answer. The inmate is 65 years old and now, because of the aging process, is experiencing serious deterioration. So compare that to the previous set of criteria. Add serious, but subtract impact on the ability to get along. No requirement of that kind. So more of this, less of that, for a given inmate, you may find the person qualifies. So now we're into the second big bucket, family circumstances. And there are two subcategories under family circumstances. One is the death or incapacitation of the caregiver for the inmate's minor child or children. The other is incapacitation of the inmate's spouse or registered partner, where the inmate would be that person's only remaining available caregiver. Note the difference between the two. There doesn't have to be an absence of other available parental figure for when you have death or incapacitation of the other parent, right? Parents have preference over any caregiver, any other caregiver under this provision when you're talking about children, and that's only right. Whereas if it's the incapacitation of the spouse, you do look at the potential for other family members to step in. Now, big bucket, other circumstances. As I mentioned before, policy statement of the Sentencing Commission 1B1.13 has a catch-all at the end that refers to other circumstances, other reasons as determined by the BOP. So you could scour BOP program statement 5050.50 as amended in January of 2019 following the enactment of the First Step Act. And I think that there is a link being provided to you with the downloadable materials to access a copy of that yourself. And you could read through that, and you may find other criteria that your client meets that are determined by the BOP that are slightly different from the Sentencing Commission criteria, or very different even. And if so, then you come within this Sentencing Commission policy, and the Sentencing Commission policy, a decision by the judge, would be consistent with Sentencing Commission policy. But is this binding on the courts that the other circumstance be as defined by the BOP, when one of the main points of the First Step Act was to remove the BOP's authority from this process because they had a 25, 30-year history of abusing that authority. And they were then, Congress meant to write them out, but the Sentencing Commission has not written them out by amending the policy since December. And why have they not? You want to tell us, Shon?
Well, because the Sentencing Commission no longer has a quorum to do any alterations of the sentencing guidelines. And the White House has not renominated the two members previously nominated to the Sentencing Commission, one of which was opposed by FAMM. And there's no indication that they're going to do so anytime soon.
So the agency's unable, the commission is unable to fulfill its authority under the Act in response to the favorable amendments in the Act. What is the significance of that then to a judge making a decision under a statute that requires the judge to act consistently with their policy, but the commission's policy has not been amended to conform to a wonderful statutory construction administrative law problem which will play out differently in different cases for lawyers. It provides an opportunity for advocacy for your client if they get caught in this trap. So I will just mention, and I cited a Supreme Court case there. I always love to cite this case because it happens to be one in which I was appointed to represent the prisoner before the Supreme Court, and we lost 6-3. So anytime you get to cite that case favorably, I'm in favor of it. For example, does the Sentencing Commission's actions get deference in relation to how it plays off against the statute? And now the holding of that case, which was adverse to the prisoner in 1997, would be favorable to prisoners caught in this trap today. So let's just talk briefly about some cases that your clients have undoubtedly, if you have any cases like this coming to your attention, some client has reached out to you on Core Links or written you a letter and said, what about that Cantu case in Texas? All right? So in Cantu, in the Southern District of Texas, less than a month ago, just about a month ago, a judge looking at this situation basically said, I don't have to worry about what the Sentencing Commission tells me at all. Yep. Mr. Cantu was applied for home confinement under the other provision that I referred to that I said we weren't going to talk about, and got turned down. And the judge said, this guy ought to be on home confinement. So I'm going to use my reduction in sentence power to change his sentence from imprisonment to supervised release with home confinement, which is a lawful sentencing change, to basically to overrule the warden on what kind of confinement he should be in. This is a totally weird way to use the statute, but the judge had a legal argument, and it's very creative. So I'm not saying a lot of judges are going to do that, and it wasn't this the case also in which the judge said it was a factor that the U.S. attorney thought that the Bureau of Prisons was wrong and the judge was right. He said that's itself extraordinary, and that he called that an extraordinary reason in the opinion. So look, is that good law? Reasonable minds perhaps could differ, but it's out there, it's on Westlaw, and it's an example of the creativity that a judge can show under the statute. The other example I want to mention is this Beck case from the Middle District of North Carolina. This is a classic Carswell women's prison hospital case. Woman, early signs of breast cancer, ignored by the hospital at Carswell until it turns metastatic, and now she has breast cancer in both breasts, and she's going to die when it could have been treated if they had paid attention when she first complained. And the judge said, misconduct by the health department of the Bureau of Prisons is itself an extraordinary and compelling reason, and I'm granting it. She could have just said it's a terminal illness case, but instead the judge lambasted the Bureau of Prisons healthcare system and granted the motion in Beck. Now, in my opinion, generally that's bad for prisoners, for the judge to think that to grant the motion they have to criticize the Bureau of Prisons. I would rather, in most cases, say you don't have to pay any attention to what the Bureau of Prisons did, saying yes or no. It's in your hands. 30 days have gone by. Follow the statutory criteria and grant the motion. But look, whatever makes the judge mad and want to grant the motion, that's right. That's what worked in the Beck case. So, other circumstances as defined by the BOP, whether or not binding, as we've already talked about, right? These criteria are not exactly the same as the ones articulated by the Sentencing Commission. In some ways, they're more stringent, in which case, who needs them? But in other respects, they can be less stringent. And so you could be, may find them helpful. And I just, to reiterate, that clients can be denied by the BOP very easily because they don't meet BOP criteria and yet be fully eligible when they get to court 30 days later. Some of these BOP criteria that you will see people denied for example, is 65 years old and related to the aging process, has conditions, affecting their ability to get along in prison. You heard about that one a few minutes ago. The BOP statement version adds and has served 50% of his sentence. People who are fully eligible are being turned down because they haven't served 50% of their sentence, which is not binding on the judge, but it's binding on the warden because it's a Bureau of Prisons regulation. On the other hand, this very same provision for someone who has served 50% of their sentence, note that this provision talks about diminishing the inmate's ability to function in the correctional environment, not limited to self-care. So arguably that clause is broader and more favorable to the prisoner. So for someone who's served 50% of their sentence, this is a good criteria that they can rely on. The second category the Bureau of Prisons mentions is age 65 or older and has served the greater of 10 years or 75%. Remember when we looked at the Sentencing Commission a few minutes ago, it was the lesser of 10 years or 75%. Well, why would that ever be better? Because under this provision, there's no requirement of a health consideration under the program statement. So you may have someone who meets the greater of 10 years or 75% because the sentence is the right length for the math to work, and yet doesn't have a health consideration factor that would otherwise make them not qualified under the Sentencing Commission criteria. So reading all the provisions is certainly, for a given inmate, a given client, is the point. BOP has a third other grounds criterion. Age 70 or older has served 30 years and no other factors. There's nothing like that in the Sentencing Commission. So if you have someone who's pretty old and is a real long-termer, is lifer, say, that would be, typically these would be lifers or people with ludicrously long sentences, and no other factors are important. This is quite similar to a similar provision in the statute under C1A2 that we're not talking about at all, that applies only to third strike cases. So again, for an older inmate who has a long-term sentence, this factor can apply and come under that other consideration bucket list. So I'm going to wrap up here by circling back to the ultimate decision made by the judge, warranted upon reconsideration of the 3553A factors to the extent those factors are applicable. This is a litigatable question. What did Congress mean by to the extent they are applicable? It does suggest that there are some 3553A factors which are not applicable in this situation. What would those be? How does the sentence compare with the sentencing guidelines that applied then? I'm not sure. But nature and circumstances of the offense, one could argue that nature and circumstances of the offense, which, as Mary pointed out, was a big problem under pre-sentencing reform, First Step Act reforms, is not a criterion under the statute which is logically applicable to the kind of decision that Congress wanted made in these cases. So you could argue that a judge who relies on the offense, the nature of the offense, is violating the statute if you needed to move for for reconsideration or, God forbid, appeal in one of these cases. Deterrence, adequate punishment, those kinds of 3553A2 factors, right, arguably are not applicable to this kind of decision. Judges may be looking at them. U.S. Attorney's Office is opposing these motions, will certainly be bringing them up, and you have an opportunity to argue under the statute that they're not applicable. Unwarranted disparity. This could be a double-edged sword. Is your client's sentence unusually long for an offense of this kind? Or in which case, an opportunity to cure unwarranted disparity in hindsight could be a positive factor. But was the sentence shorter than you might expect? Unwarranted disparity might be a factor against your client in a given case. Or you could argue, if you want to, that's not an applicable factor because it doesn't really have to do with second look, right? Which this is, right? How about the statutory provision that the judge is supposed to consider the need to provide medical care in the most effective manner? This is typically a very applicable, right? Looking forward at the time of sentencing is very different from looking backward at the inmate who's gotten older and sicker. And
The judge in Beck may have been thinking about.
Which may, if she was looking for a statutory basis, might very well. And so finally, I'm going to wrap up by saying, should the judge, and I would guess if it's a good judge, the answer should always be yes to this question. If it's a bad judge, maybe not. Is reconsidering the 3553A factors mean that part of whether the reduction is warranted should always be a new look under current circumstances, including age, of whether the sentence as viewed today is greater than necessary to achieve the social purposes that sentencing and punishment are designed to achieve. So that's my walk through the statute and the applicable regs, and I'm going to turn it over to Shon to elaborate some on what I've been talking about the opportunities for creativity.
Yeah, so I'm going to be talking about what I call second look compassionate release. A lot of people get upset with the term compassionate release because they assume that it just involves medical and age-related issues, but the statute doesn't say that. And I'm going to go backwards quite a bit, and the reason I'm going to do that is the Supreme Court has said multiple times that where Congress uses the same language in statutes, the old soil comes with that statute. And so I think it's important to understand the history of this statute. Compassionate release did not start in 1984. There was a precursor statute in the 1970s that was passed where this was used as a second look provision where judges could go back and see, had the person who had been sentenced to prison received too long a sentence, had they been rehabilitated. There are a couple cases out there that the director of the BOP at that time was filing these. There's one really interesting case where the director of the BOP said this person's sentence was too long, they have extraordinary and compelling reasons, and the U.S. Attorney's Office opposed it. So you had an interagency conflict, and the judge granted a reduction in the sentence. 1984, Congress decides to pass the Compassionate Release Statute 3582 that's in existence today. At that time, Congress had seen that this was used as a second look provision. Congress was doing quite a few things in that 1984 Act, one of which was deciding to abolish federal parole. And at the same time, Congress recognized that there would be instances where someone would receive a sentence that on reflection sometime down the road was too long, was extraordinarily too long, and may have compelling reasons why that person should be resentenced. Lots of legislative history, and I hate to do this because I don't like doing this, but I will say it anyway. The legislative history from 1984 is in a law review article of mine called Second Looks and Second Chances. Go to that. The legislative history from the 1984 Act is really good because Congress understood that there would be times where sentencing judges would issue sentences that upon reflection just were too long. And there's some good legislative history in there. The problem with the 1984 Act, of course, was Congress had seen the director of the BOP file these motions regularly in court. And so they thought, well, let's give the triggering authority to the BOP director, which turned out to be a disastrous decision because BOP going forward from 1984 rarely exercised this power. The Sentencing Commission for 20 years didn't set the criteria. And as Peter said earlier, the big change with First Step is not that the substantive criteria has changed. All First Step did was to change the procedures. And so it is incredibly important about what Congress intended in 1984 as it is what Congress intended in 2018 when they passed the First Step Act. If you can get a judge to understand that in 1984 Congress expected this to operate as a second look, but that Congress procedurally made a mistake by giving this authority to trigger sentence reductions to the BOP director rather than the federal judges, and that all First Step Act did, and First Step Act was titled, "We want to expand the use of compassionate release." All the First Step Act did was take this authority from the BOP director and now hand it over to federal judges. And so there is an argument to be made that this can operate as a second look provision. Going to the criteria set by the Sentencing Commission, it's true the statute says that the ability to reduce a sentence under compassionate release has to be consistent with the criteria set forth in 1B1.13. My view is that the Sentencing Commission, whatever they did, decided that there were other things beyond medical, beyond family, and beyond age, because they said there are other reasons that may justify extraordinary and compelling reasons. But again, these guidelines were written pre-First Step, and so they place the authority back on the BOP director. And citing back to LaBlante, Cantu, the judge there, made the case that that provision is no longer consistent with the statute as amended by the First Step Act, nor is some of the other criteria in the sentencing guidelines that say the only way a judge can grant release in this case is on motion of the BOP director. And so once you get past the other reasons have to only be determined by the BOP director, and understand that under the First Step, a judge can act without the BOP director or the warden acting. They can act and reduce a sentence even if the BOP director and the warden both say that there are not extraordinary and compelling circumstances. And so those...
Can I make sure that I was clear about the 30 days? That the 30-day lapse to go to court applies if the warden has acted in your favor, if the warden has acted against you, or if the warden has failed to act during the 30 days. There is nothing in the statute that makes it any different.
Yes, and there may be judges that say, well, I don't want to determine what is extraordinary and compelling, that this, we got to have some criteria because we're not common law judges. But, Congress does this all the time. Congress has statutes that say reasonable attorney's fees and no other guidance as to what that means. And judges act, common law judges, all the time to determine what those statutory provisions mean. And my view is, for the extraordinary and compelling reasons, nothing prevents the judge from reaching back and looking. The interesting thing about compassionate release that's different from federal habeas and other ways for people to get their sentences reduced are there's no such thing as worrying about retroactivity. There's no such thing as worrying about procedural default. As long as you exhaust and make a request to the warden, the government can't come in and claim that you procedurally defaulted any of these claims. And the other interesting that Peter mentioned before is, even if there is a sentence with a mandatory minimum, there's nothing in 3582 that says the judge can't go below the mandatory minimum. So where you have sentencing judges who are imposing mandatory minimum sentences and that don't want to, and make it very clear on the record, I'm only doing this because I have to, that might be the type of case that, a little while down the road, you would want to reapply to that judge and say you were bound at the initial sentencing phase to impose that mandatory minimum, but sentencing under compassionate release, there is no requirement that you sentence within even the statutory range. What are some of the types of cases that I think could be extraordinary and compelling? Well, I think there are a few things. I think one would be people who were sentenced under provisions of First Step, the sentencing changes, or any other sentencing reform changes that weren't made retroactively applicable by Congress. Any time where you have someone who received a really long sentence, had they been sentenced under current law today, they would have received a much lower sentence. I think you can make the argument that that is extraordinary and compelling. I also think you could make the argument that for people who received a huge trial penalty, where all of their co-defendants received a small sentence because they pleaded guilty, and the one person received a really long sentence because they exercised their constitutional right to a jury trial, and DOJ stacked a bunch of charges and got them with a long sentence, especially under 924C stacking. I think that could be an extraordinary, compelling reason. I think cultural changes could potentially. I think a lot of judges would see sentences of 30 years, 20 years, and life imprisonment for marijuana offenses. Now that marijuana is legal on the entire West Coast and that the federal government is considering reevaluating its drug policy with regards to marijuana, that could be extraordinary and compelling. The statute says rehabilitation alone is not enough. And Peter's point about the alone really plays a large role here, because yes, that alone by itself is not, but if you combine rehabilitation with some of these other reasons, maybe you convince the judge that it rises to the level of extraordinary and compelling. I think that there are all sorts of ways that lawyers could be creative in coming up with arguments about why someone received a sentence that was too long, why it's very difficult for federal judges at the outset to kind of determine who has the power to go to prison, turn it around, and come back. I often, in my law review article, make the case for Matthew Charles, who's a FAMM fellow and a good friend of ours who received a 35-year sentence in federal prison for a crack cocaine offense. When the judge sentenced him, Matthew had a really ugly criminal history. Kidnapping, had shot someone, committed some other offenses. And when the judge sentences him, he says, I think you need to be incapacitated for a long time because you're dangerous. But what the judge couldn't understand, what most judges can't possibly predict, is the ability for people to turn it around. And Matthew certainly did that. Matthew went 21 years in the Federal Bureau of Prisons without one incident report. There aren't many lawyers who have experience with the Federal Bureau of Prisons. I happen to be one of them. I'm often held up as the model of rehabilitation, and I got 2 incident reports in 11 years in federal prison, and that was only because I got caught twice. And so the fact that Matthew went 21 straight years was pretty extraordinary. And Matthew is...
mastered the art of not getting caught.
Yes, Matthew was one of these people that went to prison in their 20s and that had the capacity to turn it around. It wasn't but a few years ago that my sentencing judge, Richard G. Cuff, said, when Shon stood up at his sentencing and said he will never come back to prison and he will change, I'd have bet all the farm and all the animals that he would have never made a productive citizen. And what Shon has shown me is that, and these are his words, not mine, is that my sentencing instincts suck. I didn't think his sentencing instinct sucked. He just couldn't predict that I would have the ability to turn my life around and become rehabilitated. And that's really the message that we have to get to federal judges on these motions, is that people have the capacity to change. Now, who is unlikely to get this? People in federal prison are filing these all over the places. And one of the things when they ask me, well, do you think I have a chance? Obviously, the first thing I want to know is, who's your sentencing judge? And what did they say about you at sentencing? But the second question is, what's your prison record like? Regardless of how long your sentence is, if you have someone who has, 5 or 6 assaults or an assault on staff, even though rehabilitation alone isn't a criteria, I think practically a judge is going to look at that and be like, I am concerned that if I let you out, there's going to be issues. And that does seem unfair because a lot of times you can't predict. People have to fight in federal prison for all sorts of reasons, some of which is just self-protection. But I do think practically that it will be hard to convince judges if there is not some sort of record of rehabilitation. And so I am telling everyone in federal prison, take as many classes, do as many things you possibly can to make a good record, including getting letters of support from people in BOP. Some of my clients have 20-year history of doing the right things in prison, and letters from BOP officials who will say, this person has never been a problem. I don't think he will be a danger if he's released, will go a long way in convincing the judge to give that person a second chance. What will be some of DOJ's counter-arguments to all of this? Obviously, no warden is going to say a long sentence for whatever reason combined with a record of rehabilitation is extraordinarily compelling, because they will not want to open up this Pandora's box. The counter-arguments, I think one of which is, first step, Congress never intended to open this up for federal judges, and I'd say again, doesn't really matter what Congress intended when they were thinking about passing the first step. What matters is the text of the statute. And it's clear that Congress in 1984 intended for this to be used as a second look, and all Congress did with the First Step Act is say, we're going to give this authority back to the federal judges. If you look at the legislative history of the First Step Act, really the only thing that was mentioned was medical, even though there were all these other criterias, age and family, that were already out there. So to the extent that members of Congress didn't actually read the Sentencing Commission's criteria, I don't think that should matter. What are the other issues? Well, the sentencing criteria, this 1B1.3D, other reasons, only as determined by the BOP, but again, that seems inconsistent with the change that Congress made to the statute, and therefore that provision should no longer be binding. At the end of the day, I think many judges who have imposed sentences that they are uncomfortable with will take this authority, at least until the law is unclear on this, and resentence clients. And we will eventually have fights in federal circuit courts over whether the authority is consistent with the law. And I think having good lawyers and good lawyering will play a huge role in how this all plays out. But until then, there is nothing preventing any of you from filing motions on behalf of defendants, especially where you have judges who are uncomfortable with imposing a long sentence or a mandatory minimum in the first instance.
Shon, do you think that lawyers can play a productive role in helping inmates make the initial application in the Bureau of Prisons, or is that really fruitless? It doesn't matter. And related to that, what about jailhouse lawyers and ex-inmates who are offering to help our clients?
Well, the first question is, yes, I think, the letter to the warden sometimes matters. I think it matters a lot more in medical cases and family cases. I don't think in the second look, I don't think the best lawyering on a second look compassionate release case is going to get a warden to say yes, because I think what you're going to see is eventually a DOJ is going to write a memo and guidance saying this is not an acceptable use of compassionate release. And I think wardens' hands will be bound by that.
I'll just add, particularly in medical cases, I agree, and particularly in the family circumstances cases, because the BOP has 3 levels of review and onerous documentation requirements and proof requirements. So for us, when a family circumstances case comes to my attention, we get a lawyer to work with them from the very beginning, so that, to help them sort of get some of that stuff together, because that information will be important for the court as well.
Yeah, as to the jailhouse lawyering question, one of the things I did when I wrote the law review article and posted it on SSRN is I also posted a sample brief for people in prison to use, for lawyers to use. Why? I know because let's just say I have a large list of Core Links followers, several thousand people in federal prison I'm in contact with, and I know they are going to file these second chance. People had already been filing without the legal arguments long before I put out the law review article. And so I think we just have to give them the best legal arguments possible and hope that no matter what happens when it gets to the circuit court level, that we have good lawyers taking up those cases and presenting those to the circuit courts in the first instance. And it only takes a few circuit courts to say yes, who could end up thousands of people being released on this basis. And I think the great thing about compassionate release is, unlike most criminal law provisions in the U.S. Code, there is lots of ambiguity in these statutes. There is lots of little wiggle room to try and press the issue if you have a favorable judge. Peter and I were talking before about what happens if judges start just ignoring the criteria from the Sentencing Commission altogether, whether that would be bad. And my view is a judge that doesn't want to do this is not going to do it regardless of what legal arguments we make. And judges that do...
Because in the end, all they have to say is it's not warranted.
That's not warranted, and on my discretion, I find that it's not extraordinary and compelling. Even if it rises to a certain level, it doesn't meet that requirement. That's one of the arguments, I think, for why just because people who were sentenced under provisions of First Step that weren't made retroactive, why Congress could have still wanted them to have federal judges to resentence those people. You know, if Congress had made 924C stacking retroactive, that would have been a categorical change that would have allowed everyone who received a 924C stacking conviction to be resentenced. Congress may not have wanted to do that. Under compassionate release, not only would they have to show that they received a sentence under 924C, but they would have to meet the extraordinary and compelling reasons, which probably means more than just I received a sentence under 924C. Probably means I received a sentence under 924C, maybe it was due to a trial penalty, on top of, hey, listen, I have a pretty good record of rehabilitation in the Federal Bureau of Prisons. And so this is an individualized basis for judges to look at each individual case and decide whether they merit a reduction in sentence.
And here's why you should think I'm not dangerous, even though I repeatedly used a firearm to commit an offense.
Yes, because things have changed. And, you know, especially for your clients that were sentenced in their early 20s, and now 20 years later, they're a different person, just like anyone is when they go from 20 to 40. This is why you bring this to the attention of the judge and say, this person, you know, committed these offenses, but that's not the person. Matthew Charles today is not the person Matthew Charles was at 28. I'm not today, at 44, the same person I was at 21 when I committed the offense. And I think this idea of second chances, I think there are federal judges who will run with this until they can't.
All right.
Well, that turns it right over to Mary.
I might interrupt just to weave in. We only have one question. We only have one question from a viewer, so I thought I'd weave it into your presentation, if that's okay. And here it is. In cases where clients are awaiting sentencing and not just utilizing 3553A factors, how do we argue parts of the First Step Act and age to the sentencing court? For example, individual A has been in custody on a fraud case for 2 years awaiting sentencing and is in their late 60s. So is there a way to use what Congress has done here on the front end?
Well, those factors have always been valid under 3553A, A1, to justify a modified sentence since Booker, for sure.
Yep.
And, my reaction is that to that question is, well, there's another example of how this law reform is a double-edged sword, right? Telling the judge Congress, was more sensitive to how people, can change when they're older, then might induce your judge at sentencing to say, great, come back in 3 years and then we'll talk about it again, and not do it now. I could see that double-edged sword coming into play.
I think for some of the provisions of First Step Act that changed sentencing that weren't retroactively applicable, I think for those under the 3553A factors, one of the things that the government and judges love to say is, well, I can't reduce your sentence because it will reduce the severity of the offense. And now you have 87 votes in the U.S. Senate for reducing the severity of offenses, and I think to the extent that people have defendants who are going to be sentenced under those provisions, that is one arrow in the quiver you can use under the 3553A factors to say sentence is no greater than necessary, and Congress has found that some of these punishments were too long and unjust and reduce them.
And you're referring not to so much to this chapter of the First Step Act, but to other provisions.
Yes.
So this is my pitch for lawyers to support prisoners who are seeking compassionate release under what are considered the kind of traditional aspects of it, but also to push the envelope. Prisoners can't do this without counsel,
Once they get to
and
court.
they have to be, well, and even before that. I think, for example, in the family circumstances cases and some of the terminal cases, or when a prisoner is not competent to write their own motion because they are cognitively so impaired. Lawyers, we're involving lawyers at very early stages or when prisoners are already in court. So FAMM, in conjunction with NACDL, in partnership to some extent with Shon, who has advised us, and with the Washington Lawyers Committee, has set up a compassionate release clearinghouse. And it has two simple tasks. It is to find prisoners who may be in need of compassionate release and find lawyers who can represent them pro bono. It works in a pretty straightforward way. FAMM is in constant communication with 40,000 federal prisoners on the CoreLink system. We advise them about the changes to the law. We asked them if they thought that they were eligible for it. We heard back from hundreds of people. We gathered information about them. We triaged for the most serious cases. And we told them two things. Don't file pro se, sorry, Shon, because pro se petitions are making bad law. But people do anyway, so we try and get lawyers involved at that stage. But we definitely try and get lawyers involved when it looks pretty clear the Bureau of Prisons is going to not help. What's happening is that the government in those pro se cases, judges are not appointing lawyers and the government's coming in and opposing, and you might need experts and you might need expert testimony and evidentiary hearings. Prisoners don't handle these on their own. So would you flip the slide for me? So we have a compassionate release clearinghouse. That's how you get in touch with us, or you can contact any one of us. And I just want to say that for years, at the end of the game, when the Bureau of Prisons director said no to somebody, all I had to say was, I'm sorry. And now I get to say, hang on, let me see if we can find you a lawyer. So hopefully, if you can support this effort pro bono, we'd love to hear from you.
Yes. And thank you, Mary, for all the work you've done on compassionate release over the years.
Thank you. Thanks for helping push the envelope and for all the good work.
If people have other questions, we are going to stick around a few minutes. You can email Kyle.
Nope.
Okay.
Okay.